Hi, I'm Jo Sullivan and I'm a family lawyer specialising in processes that avoid court, so mediation and collaborative practice, and we're going to talk a bit more about what they are. There are various forms of dispute resolution, all of which of course avoid court. They very much depend on how far the parties are in discussing things and how well they're able to talk to each other. So the first one I would say would be do-it-yourself or kitchen table agreements. The second would be mediation. The third would be collaborative practice, and the fourth would be arbitration. So kitchen table agreements or do-it-yourself agreements are those where the couple sit around a table basically and try and work things out together. They can use a parenting plan, for example, to work out what things will look like after they've separated, and of course to keep revisiting that document as the children grow up. This particularly suits people who are really quite emotionally mature, really. They have dealt with their separation. They are able to talk to each other and be in the same room together. And they don't necessarily need the help of another professional. Mediation is where a professional who's, in my instance, a family solicitor, is also a mediator, is trained to be impartial and independent of both of you. You come and see the mediator for 1.5 hour sessions, depending on how many sessions you need. And the mediator will go through the options with you and reality test them. Mediation is often confused with reconciliation. And obviously reconciliation is when people are trying to get back together to reconcile their relationship. Mediators are not in the business of getting you back together. Mediators try and help you move forward separately. Children are at the heart of the mediation process. However, children are not actually in the mediation session with the parents. It's quite a distinct form of training that the mediator will have received. The mediator can meet with the children, or one child at a time, and essentially try to draw out from the child or children what's been going on and what perhaps they might like to happen. The mediator then talks to the parents about what the child has said, if you like, relaying a message from the child or children to the parents. Collaborative practice is where each of the parties has their own solicitor who's a collaboratively trained lawyer. And what we do quite simply is sit around the table, the four of us, having four-way meetings until we resolve all the issues. So there's a collaborative process is about having a series of meetings rather than writing letters to each other or going to court. So the great advantage of collaborative practice is that whilst the process is going on, each of the couple get their own legal advice given openly in front of the other solicitor and the other party. This leads to openness. There's no secrets. There are no games playing. No one wins. It's a question of what suits this family in all these circumstances. During collaborative practice, it's an ideal opportunity to involve other practitioners apart from collaborative lawyers. So we might, for example, need the help of a coach, a money coach, an independent financial advisor, perhaps an accountant. It may seem odd to involve all these other people, but the reality is if the couple used an ordinary process, the ordinary traditional process, these people are involved anyway. For example, parenting experts, perhaps even getting parenting reports. All of these things help the couple move forward. Arbitration is quite new to family law in England and Wales. It's a bit like court, but not being at court. So the idea is that you take your case to an arbitrator who will ask for the same kinds of documents that a judge would ask for, except you're not in court. It's confidential, so no one will know about what's happening, which is very important to some people. It's much cheaper and it's much quicker, depending on the diary of the arbitrator. I think in terms of most dispute resolution processes, it might be something to consider. For example, if there's one issue at mediation that people can't reach agreement on, or one issue in collaborative practice, they could take that one issue, for example, to the arbitrator to make a final decision on. An example of where arbitration might be helpful on a single issue could be something like the celebration of religious holidays. Both parties want, for example, if we're talking about Christmas, both of the parties want the children to spend Christmas Day with them. they've been through all the different ways of thinking about things, which might be what one parent has one Christmas, the other has the next Christmas, or perhaps splitting the day in two. But the couple really can't reach agreement on it. There might be lots of good reasons why they can't reach agreement on it, in which case they can present their evidence to an arbitrator who will make a final decision, and the couple agree that they will abide by whatever that decision is.